Within that broad topic, my lords, I indicated, I'll now break it down. I'll break it down by first posing this question, or the beginning of it is the judgment that was delivered by this Honorable Court on 1st September 2017. In that judgment, my lords, what happened is that the declaration of results was invalidated. It is so important to bear that in mind because it was an invalidation of the declaration of the presidential elections. A few of my colleagues have referred to that judgment as having declared the election null and void. Nothing could be further from the truth. It was a declaration that was invalidated. Point number 2, the election was to be held under Article 140, sub-Article 3. And immediately thereafter, my lords, we agonized as to what is the operative law for the conduct of an election under Article 140, sub-Article 3. Why did we agonize, my lords? Because the first question was, is there a nomination process? As my lords are aware, nominations under Article 137 are nominations by a political party. After nominations by the political party, then Article 138 kicks in because those candidates will be nominated as well by IEBC, and then under Article 138(1), if it's only one candidate, he is declared the president-elect. If there are two candidates, then an election will be held. So, my lords, the first question was, is there a nomination necessary for the fresh presidential election? And allow me to say this, nowhere in the Constitution is there a provision that under Article 140, sub-Article 3, nominations are required. So we had to fall back to the Elections Act. The Elections Act, my lords, Article 14, provides that nomination will be necessary for a general election. Nominations are also necessary for an election under Article 138, sub-Article 5. And finally, nominations are necessary in the event the office of president becomes vacant. Those are the three situations in which nominations are necessary under Section 14 of the Elections Act. Let me deal with this issue perhaps straight away. It is understandable why nominations are necessary for a general election. For the simple reason, there's no candidate. All political parties would have to nominate their candidates. It's also understandable why nominations would be necessary in the event the office becomes vacant. Why? Because there is no candidate and no political parties would have to nominate. But under Article 138, sub-Article 5, in my submission, National Assembly made a mistake. Because under Article 135, sub-Article 138, sub-Article 5, the candidates are already declared by the Constitution. And the candidates, my lords, are set out. If no candidate is in the runoff, is the candidate or candidate who received the greatest number of votes and who received the greatest number of votes. So Parliament made an error in saying that there can be a nomination process under 138, sub-Article 5. And it will be important, my lords, for Parliament or National Assembly to rectify that error, because nominations cannot, or you cannot legislate in Parliament counter or contrary to the constitutional provision. My Lord is with me? That is, so that is the first point. There is an error there. 138, sub-article 5, in my submission, does not require a nomination process. Naturally, not the party, political party nomination, and not the IEBC nomination, because the candidates are already declared by the Constitution who the candidates will be in the runoff. I say this, my lords, to demonstrate how agonizing it was to know the operative law for this new or fresh presidential election. Having not seen any signs of hope in the Constitution or the Elections Act, IEBC and the lawyers who assist political players, we then stumbled on the 2013 decision of this Honorable Court. We stumbled on it, my lords, and in it, we found a ray of hope. The ray of hope is paragraph 289. I will read it to you, my lords. It is clear that a fresh election under Article 140, sub-article 3, is triggered by the invalidation of the election of the declared president-elect by the Supreme Court following a successful petition against such election. Such a fresh election is built on the foundations of the invalidated election. It can, in our opinion, only involve candidates who participated in the original election. Very important here, my lords. In that case, there will be no basis for fresh nomination of candidates for the resultant electoral contest. So we actually saw what we are looking for. There will be no nomination in the fresh election. So straight away, my lords, we now have a law that can guide us. This became the controlling judicial pronouncement for the conduct of the fresh presidential election, the controlling judicial authority. Number two, because there will be no fresh nomination of candidates, then paragraph 291 also gave us another lay or another principle, because in the paragraph 291, the candidates to participate are set out. The candidates to participate are the president-elect and the runner-up. It is in paragraph 291. Having seen this judicial pronouncement soon after 1st September, it then explains why on 5th September, only 2 candidates were gazetted for the fresh presidential election. And in that Gazette notice, my lords, it is clearly indicated no nomination is required. Authority for that, the Supreme Court judgment, which was the controlling judicial pronouncement as at that time. But paragraph 291 also said the other candidates in the invalidated election will be assumed to have conceded, I repeat the words, assumed to have conceded or acquiesced in the results. Those are the words of the Supreme Court. And as fate would have it, the following day, 6th September, one of the candidates, Dr. Ekulu, made an approach to this court. He filed a case in this court to say he never conceded defeat. and he cannot be assumed to have conceded defeat. That application was placed before the court, or it was accepted by the court, but ultimately, the Chief Justice, exercising powers vested in him, held that that challenge or that petition was actually a challenge based on a Bill of Rights, and it ought to be heard in the High Court. So, my lords, the next step in my analysis is Dr. Ekulu's case in the High Court. Ekulu Okoth's case in the High Court, my lords, was based on Article 27 of the Constitution, based on Article 38 of the Constitution, plus many other articles. Why do I pick on 27? Because 27 deals with equality, and 38 is the article that entitles him to offer himself to be elected for office. My lords, that case was litigated in the High Court, and as that litigation was going on, a very important step took place. On 10th October, one of the two candidates, we have narrowed down this to the two candidates, the NASA candidate abandoned the electoral contest. 10th October. In both petitions, the word withdrawal and abandonment are used interchangeably. As I'll demonstrate, my lords, withdrawal has a specific legal significance and legal meaning. It applies when one calls in aid Regulation 52. That is time-based. Abandonment, on the contrary, is an exercise of freedom of choice. It's a free will demonstration. At any time, exercising free will, one can abandon a contest. My lords, I'll take that this was abandonment of the electoral contest. I go back to the controlling authority. In this controlling authority, paragraph 290, I'll read it out to my lords. Suppose, however, that the candidates or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date, then the provisions of Article 138(1), paragraph B, would become applicable with fresh nominations ensuing. So if that abandonment on 10th October was fully activated, then it would have led to the so-called, it would have led to being equated with Article 138(1)B, and fresh nominations would have become necessary.
Mr. Ngatia, that was corrected. It refers to Article 138(8).
Yes.
B.
Correct.
Not 1.
Yes.
Yes.
I wanted to make that correction.
Okay.
But the point, my lord, is this, that if that abandonment, again, this controlling authority was fully implemented, what it would have meant is fresh nominations would have become necessary. And my lords will now see where I'm driving the argument. The contest in both petitions is that fresh nominations were necessary. The only foundation of fresh nominations would be the application of paragraph 290. But a very significant event took place the following day. On 11th October, my lords, a very significant event took place in the judicial history of this country. Judgment in Dr. Ekulu Okoth's case was pronounced by the High Court. In that judgment, my lords, the judge first and foremost analyzed the case by Dr. Ekulo and held that he actually had a constitutional right founded on Articles 27 and 38 to contest in the fresh presidential election. Number two, my lords, the judge held that the paragraphs I've taken my lords through were obiter dicta. So what previously to us as legal advisors were the controlling authority, now the High Court said those were obiter dicta, they were not binding, and all the candidates in the invalidated election have a constitutional right to participate in the fresh presidential election. That took place the day after abandonment. What does this mean? This means, my lords, that another judicial pronouncement became the regulating authority. It regulated the period from 11th of October. It had to be implemented, and what IBC did, and they cannot be faulted for doing that, was to now allow another gazette notice to be published in which they had the names of 5 candidates. The only omitted candidate was one of the candidates because he had a legal impediment, and that legal impediment, my lords, is common ground. As soon as that legal impediment was again suspended by the High Court, that candidate was put, there was another gazette notice. So, my lords, as to the question, what was the guiding law regarding the conduct of this election, there are those 2 cases, those 2 judgments, each from 1st September to 10th, no, not 1st September to 10th October, then from 11th October up to the time of the fresh presidential election. 2 judgments each operating within that period of time. My lords, can IBC be faulted? In my submission, they cannot be faulted. They obeyed the law as set out in the 2 judgments. And my lords will notice that the political participants in the contest, none of them ever challenged those positions, because in my submission, those positions reflected the correct position in law. Therefore, my lords, as regards this question, which I posed right from the word go, what was the law that regulated this election? The law was the 2 judgments, each operating at a certain period in time. I go back to the...
Before you go back, Mr. Ngatia.
Yes, my lord.
You have read that paragraph about abandonment.
Yes.
Had Dr. Kuro not come in, what would have been your position?
Not Dr. Ekulu, but the High Court. The High Court judgment. If the High Court judgment didn't come in, the Court of Appeal judgment would have continued to be the controlling judgment. Supreme Court judgment. Thank you.
Yeah, with what effect?
There would have been need for fresh nominations. Yes. Unless, of course, there was a contest. And in this, my lord may have seen that this is, the Kenyans have become so litigious as regards these matters, but if there was no contest, that would have been the controlling authority.
Mr. Ngatia, is that correct really? Because you've just said that on the 5th of September, the judgment was on the 1st, and on the 5th, IEBC, for whom you do not act, send out a notice, a gazette notice, saying
Yes.
who the candidates would be.
Yes.
The Mativo judgment was on the 11th of October.
Yes.
But 5 days earlier, IBC has said only 2 people are participating.
Yes.
So when would these nominations have been done?
It would have been very difficult. I agree. It would have been very difficult.
Just let your argument flow.
Yes, because 5th September, then the controlling authority, no nominations are required. And then there is the abandonment, which is on 10th of October. It would have been very difficult for nominations to have taken place.
So are you amending your answer to the Chief Justice's question?
I'll do it at 2 levels. I would answer the Chief Justice at a theoretical level. Theoretical, oblivious of the period of 60 days that the authority would then have called for nominations. But from a practical angle, it would have been difficult for nominations to take place because of the 60-day period. And as we are aware, the law cannot command the impossibility. So in all probability, that would have triggered a case in the High Court or possibly in this court to be for nominations not to take place. My Lords, this issue of abandonment must be seen in the context in which one requires to see it for what it is. And the question would be, in an electoral cycle that is prescribed by law to take place within a period of 60 days, can a candidate be allowed to stop the cycle by making an abandonment so that another cycle starts? Perhaps for the Chief Justice, I could repeat this again. We start off with a prescribed period of 60 days. Say there are 2 candidates or whatever number of candidates. The election must be held within 60 days to comply with the constitutional imperative. Say on the 50th day, one candidate abandons the contest. And then if that is to happen and the elections are postponed, and then another contest, another cycle starts because you can't have nominations. My Lords, I am driving to a point which is difficult to understand, where one can get into a circular argument that you are in an electoral contest, a contestant abandons, requiring another contest to get into place, and then abandon yet again, and that will be a very dangerous position. I'll deal with it as I come towards the end of my submissions. My Lords, I conclude the first bit of my submissions by requesting you to hold and to find that as regards the first aspect of 2 candidates, that was in accordance with a pronouncement of this Honorable Court, the candidates, as well as IABC and the society for that matter, were perfectly entitled to comply with a judicial pronouncement from this court. And for the enlarged number of candidates, I would urge you, my lords, to hold and find that that was also in compliance with a subsequent High Court judgment. And since it was in compliance with a subsequent judgment, the candidates, as well as IEBC and the society, were perfectly entitled to comply with that judicial pronouncement. Where does that lead us, my lords? The judgment of the High Court became the subject of an appeal. This appeal is now in the Court of Appeal. It is an appeal regarding three distinct questions. Question number one, the application of Articles 27 and 38 to the candidates. The judgment is in rem. Second question, definition of fresh presidential election under Article 140, sub-Article 3. That is a ground in that appeal. And number three, whether those rights, my lords, which actually now go back to the date of nomination, whether those rights are rights which ought to be recognized by the Constitution. All those, my lords, are matters which are actively being pursued, and as regards that, my lords, it is important I point this out. The contest in the High Court is properly in that court, or was properly in that court under Article 165. An appeal is properly in the Court of Appeal through appellate process, and in all probability, a further appeal is likely to come to you, again, through an appellate process. So as regards all those appellate processes, my lords, I would urge you to hold and find that it will not be correct for you to pronounce yourself as regards those contested rights within the parameters of this presidential dispute. Those are matters which, as you clearly indicated in advisory opinion number 2, ought to be dealt with by the competent courts exercising their technical competence, and through the appellate process, those matters may ultimately come to this honorable court. Before they come, it would be, in my submission, not be correct to pronounce on any aspect of those contested issues. My lords, still on the broad question that I indicated, the question of Jirongo and when he came into the contest are not matters which have been raised by the candidate or any of the other presidential candidates. They cannot be introduced by a signed weed. Whether they got enough time or not, that is personal rights. It is for them and them alone to raise such issues. Suffice to say, my lords, that none of the candidates has raised any of those rights. My lords, I then go to another area, also a constitutional law area, which is the Election Laws Amendment Bill, which is now an act, which was legislated by National Assembly and became law on 2nd November this year. We have an affidavit, my lords, of Honorable Duale, Leader of Majority in the National Assembly, detailing all the steps that were taken by National Assembly throughout the legislative process of that bill. My Lords, in the fullness of time, you will notice that there was a lot of public participation in the legislative process. Civil society groups were invited, law society was invited, religious groups were invited, and virtually every group was given an opportunity to indicate their position regarding the proposed amendments. National Assembly, and this does not require any authority, has the legislative authority to consider what laws are suitable, and in that process, it is a process that is an exercise of the sovereign right of the people of Kenya. My Lords, ultimately, the bill became law, as I indicated, on 2nd November this year, and one of the clauses in the bill is to amend the former Section 83 of the Elections Act. That section, my Lords, as you're fully aware, was in the alternative. And in the amendment, it is now conjoined. Two criteria are required as an election court is considering what orders to make in respect to an electoral dispute. These are all the electoral disputes. It's not limited to a presidential or any dispute. So as to the first challenge as to whether that bill is constitutional, my submissions are as follows. First, we start with the presumption that a statute is constitutional unless a contrary position is demonstrated. In my submission, no contrary position is demonstrated. What is demonstrated is that the legislative process followed all the steps that were required. The second challenge is a challenge limited to Section 83, that it should not apply in this case. Why it should not apply in this case, I am not able to understand. As I indicated, it became law on 2nd November this year. This petition was filed, to be gratuitous to one of the petitioners, on 6th November this year. So it was filed 4 days after the law had been amended. So at the time that these petitions, or both petitions, were filed, the governing law in Kenya as regards Section 83 is the 83 as amended. In my submission, my Lords, it will be incorrect for an argument to be made to a court that although I appreciate that the governing law is this law, nonetheless apply the repealed law. Can you apply a repealed law? In my submission, my Lords, it is not possible for a court to apply a repealed law because by the process of repeal, the law ceases to exist. This is a point I argued quite some years back in the High Court. Allow me, my Lords, to refer to a High Court decision. This is Miscellaneous 131 of 1996, National Housing Corporation against Intex, And the question in that case, my Lord, arose in this way. I'll take only a minute of your time. We conducted an arbitration. During the time of the conduct of the arbitration, the regulating law was Cap 49. At the time the award was made, the law had been amended, that Cap 49 had been repealed, and the Arbitration Act 1995 was the law in place. So to set aside the interim award, I used an Arbitration Act 1995, and a challenge was immediately made that you can't. You ought to go under Cap 49. And the High Court judge, I'll read this, my lords, because it's very brief. The application to set aside the interim award was made when the Arbitration Act 1995 was in operation, as at that time, Cap 49 had been rescinded or revoked or cancelled or replaced. The only substratum existing as at 20th February 1996 was the Arbitration Act 1995. And the court, the judge, had no difficulty in holding the minute the previous law ceases to be the law in Kenya. The only law which can be applied is the law which is existing at the time of the dispute. So the law now existing is the Section 83 as amended. My lords, I would request and urge you to hold and find that Section 83 is constitutional, and more important, it applies to this dispute and applies to all the disputes currently in courts in Kenya. I think it's my learned friend, Mr. Waikwa, for Katiba Institute, who not too long ago approached the High Court saying that the bill or the act, as it's now an act, is unconstitutional. I'm referring to the Election Laws Amendment Act, my lords. That contest is a live contest in the High Court. Yes, Mr. Waikwa, Mr. Omtata, quite a number of my good friends have gone to the High Court to challenge and say that the act is unconstitutional. And the High Court is again being requested to make a determination on whether the act is constitutional. The High Court is exercising the power under Article 165, sub-Article 3, paragraph D. My lords, that is a live contest in the proper courts. Once again, I'll request you, my lords, to decline any invitation. Decline any invitation made to you to, at this stage, declare whether the act is constitutional or is not constitutional. Because that is a live contest in the proper court. But because the act is an act of parliament, regularly legislated, it ought to be applied unless the High Court or any other court exercising an appellate process declares that that law is invalid. Before any such declaration, my lords, that becomes the regulating law within our republic. My lords, I'm looking for some notes I had, but I can still argue from memory, I think. The last point I would wish to discuss is a point that was raised once again by my good friend, Mr. Waikwa, yesterday in his submissions. He submitted that no opportunity was given to voters in 27 constituencies to exercise their constitutional right. 27 number 1 is erroneous because that includes the constituency in Turkana and Fafi. You remove those 2 constituencies, you are left with a number of 25 constituencies. In his argument, my lords, he very passionately urged that because there wasn't an election in those 25 constituencies, that would be enough ground to invalidate the fresh presidential election. So I took it with the seriousness that it requires. First, my lords, on the facts, Mr. Waikwa is, with respect, in error. In error because of the following facts which are not in dispute. IEBC, together with other agencies that facilitate the conduct of elections, had an infrastructure in all the 291 constituencies. The infrastructure included the following. Polling stations were gazetted in each of the 291 constituencies. Returning officers were gazetted in each of those constituencies. Polling clerks were all recruited, and more important, my lords, ballot papers were procured at taxpayers' expense. There is no contest as regards each of those facts I have analyzed. Therefore, a complete infrastructure for holding elections was in place. Regrettably, and I say this as a Kenyan, through localized insurgencies, a state of insecurity, unprecedented insecurity, was experienced in those areas. Made voters who would otherwise have wanted to vote not to exercise that right, and those who didn't want to vote became the beneficiaries of that mayhem. My lords, you are now confronted with a very unusual position. Can our apex court allow localized insurgencies to be grounds of invalidation of a contest? And this is at all levels of electoral contest. Could an MCA, for example, ensure that in certain pockets in that ward, no elections take place, and then approach the court and say there were pockets where, or polling stations where no elections were held? And that, my lords, takes me to a very important constitutional question, which is the question of that request being the incentive to do wrong. An incentive to do wrong would be that a person who now wants to enjoy or benefit from his wrongdoing. It is a perverse incentive, because we ordinarily use the word incentive for doing good. It becomes a perverse incentive because it's the incentive to do wrong. And that takes us to what I had alluded to, a circular argument. The argument would be there is a contest, before the contest or at the point of the contest, one uses local youth to ensure that in some pockets in the country, there are no elections. And then you use that to invalidate the result. If we were to allow that, then we'll be on a permanent circle, because then with the perverse incentive that you can actually get the elections nullified because certain areas did not vote, then that becomes a very good incentive for our political players at all levels. I would urge you, my lords, in all humility, as a court that has got the constitutional mandate to ensure that there is governance in this country, and governance which is based on the Constitution, to very, very strongly say you cannot invalidate an election on those bases. My lords, that is a very humble and passionate plea, because it is for this court to give guidance to political players at all levels as to what is permissible and what is not permissible. We must now inculcate a culture in this society as to what is permissible and what is not permissible. No court other than this court has that authority. It is only this court which has that authority to uphold a regular conduct of elections, and that governments shall be in accordance with the Constitution. My lords will notice in the fullness of time that the other arguments, and I'll be very brief about this, is about turnout. Turnout really is not an argument. In Kenya, there is no compulsory voting mechanism. It's a freedom of choice. And in any case, my lords, what is thrown at us is so easy to, we will not use the word throw back at them, but to just demonstrate how incorrect those positions are. I very quickly turn to the affidavit of Winning Guchu, Volume 1, document number 17, in which, my lords, we have set out the turnout in by-elections, because the fresh presidential election is akin to what in Kenya would be by-elections. And, my lords, we have a it's set out in the affidavit of Winning Guchu. You find it, my lords, at paragraph 21, document marked 17, and I'll only take 3 or so examples. We had a by-election in Makueni County in September 2013. Voter turnout, 24%, 24. We had a by-election in Kajiado Central Constituency, March 2015, voter turnout 12%, 1-2. We had a by-election in March last year, March 2016, in Malindi constituency. Voter turnout 16%, 1-6. Finally, we had, my Lord Chief Justice, a by-election, another one in 2013 in Kibwezi West. Voter turnout 21%. I have highlighted areas where our competitors, their candidates won with those percentages. My lords, 39 is way above the figures I have stated. My lords, I therefore urge you to hold and find, and this I would now do as my last point, Masharia. We found a further supplementary list of authorities in which a similar situation confronted our neighbors in South Africa. Supplementary list of third respondents, further supplementary list of authorities. I have seen it, Kirago. This is a case from the Constitutional Court of South Africa. We found this fairly late. And my lords, I will go directly to the point. Paragraph 137, Constitutional Court of South Africa said as follows. It bears emphasis that this is an exceptional case that cries out for an exceptional solution or remedy to avoid a constitutional crisis which could have grave consequences. It is about the upper guardian of our constitution responding to its core mandate by preserving the integrity of our constitutional democracy. My lords, you are in that position. We are requesting you to respond to your core mandate of ensuring that this nation, this republic will retain its constitutional democracy. In our submission, my lords, in exercising that mandate as the honorary guardian, in South Africa they are saying upper guardian, in Kenya you are the honorary guardian for this contest. Exercising that mandate, I would urge you to hold and find. You cannot allow this republic to get into a circular operation of repeat elections over and over again, because we'll get into a constitutional crisis. I would urge you, therefore, my lords, to hold and find that these two petitions are not merited and to dismiss them. My last point is this. For John Harun Mwau, when you retire, you'll notice, my lords, that he pleads that he knew of this issue of nomination on 5th September this year. That's when he knew of the issue of nominations. He did nothing about it until a week before the date of the elections. He went to our High Court, a very vibrant High Court, to seek an order to stop the fresh presidential election. It is in that case that I made a preliminary objection which was not read out to you. I did not admit that nominations are necessary. I said the pivotal point in his case is that no nominations were held. That is a contest that can only be found in the Supreme Court. To make a submission in court is not the same as admitting that nominations are required. It's a small point, my lords. I'm sure you read it. The judge has very, very rightly written down what my submission was. I made a preliminary objection that the High Court has no jurisdiction because the contest is about nominations. The judge upheld the position. The question I ask is this, my lords. In the kind of pacific dispute resolution that this country should have if we are to retain our constitutional democracy, should we countenance a situation where a citizen waits until the last minute, and he wants now to block the process. Wait until the last moment. Because as at 5th September, this law-abiding citizen, as he describes himself, and I have no doubt he is, could have gone to the IEBC tribunal and litigated about the question of nominations. We would have benefited from it and implemented the decision. Why wait until the last day of the electoral contest and then come to bring the country to its knees? And the same holds true in the next petition. Each and every of those complaints raised should have been raised in good time. My lords, please let's not allow ourselves or this nation to slide back to a very dark era which we cannot even contemplate. Unless my lords have any questions, that will be all from me.